Hello and welcome to this AELE webinar. Before we begin, a few words about the webinar. This webinar is for general information purposes only and does not constitute legal or professional advice. No user should act based on any material contained in the webinar without obtaining proper legal or other professional advice specific to his or her situation. Presenters use reliable sources and practical methods to ensure information accuracy, and the Americans for Effective Law Enforcement, also called AELE, is not responsible for any errors, decisions or omissions of the information. Shared information is in good faith and it is only for general purpose. It should not be relied upon for any specific purpose and no representation or warranty about its accuracy or completeness are implied. The views expressed by speakers or other third parties in AELE webinars are those of the speaker or third party and not, necessarily, of the AELE. Information presented by a speaker or third party does not make AELE provide any warranty, express or implied, including warranties of merchantability and fitness of particular purpose, and specifically disclaims any legal liability or responsibility for the accuracy, completeness, or usefulness of any information, product, service or process presented, and makes no representation that its use will not infringe upon privately owned rights. Presentation or representation of any material or information by a third party regarding any specific opinion, commercial product, process, or service by trade name, trademark, manufacturer, or otherwise, does not constitute or imply AELE's endorsement or recommendation of such opinion, process, service, item, or organization. Any such material or information presented by a third party in any format at an AELE hosted event, without limitation, is for informational purposes only.
Great morning. I'm not sure what's going on, but there's some technical difficulties. So what we're going to do is I'm just going to go ahead and get started. And if somebody else needs to chime in, that's what we will do. And now let's see if I can share the screen. Great morning. Rather than go into a long detailed introduction, let's just get started because we're already several minutes into this and I don't want to waste your time. What we're going to talk about today are law enforcement use of force accountability, definitions, qualified immunity, standards, degrees of certainty, and a little bit about junk science. My name is Michael Brave, and I'm manager and member of Law International LLC, which has been in existence in one form or another since 1989. Some of the things we're not going to talk about this morning, simply because we are not going to have time, are frequencies of law enforcement activities, force temporal-related deaths in any significant detail, excited delirium syndrome, restraint, conducted energy weapon use, weapon compliance, shootings, pursuit temporal deaths, etc. We're discussing doing one of these in the future where we go into all of the numbers and all of the data dealing with each of those issues. We're also not going to do a full program on policies, meaning trade-offs, structures, foreseeable consequences of policy statements and development, etc. And we're also not going to talk about who should be drafting, reviewing, approving policies, procedures, and guidelines. I will be talking about my objective annotated chronological timeline, but not in huge detail. Specific force principles, such as resistance triage, immediate threat triage, conducted electrical weapon bioelectrical basics, myths, and realities. We're just not going to have time for that. If people want to see those, we are discussing doing them in the future if there's enough interest. I do want to give you a couple disclaimers before we get started. First, while these incidents are very rare, they are incredibly important for the officer or the people it happens to. In other words, if the officer is dealing with a once in a 10 million encounter event, the officer doing that really doesn't care how rare it is if the officer is going to get criminally prosecuted, civilly sued, or lose his or her job or their family over it. Second, I want to point out that I am going to be, in perfect 2020 hindsight, critical of some things that I've seen occur in various cases, but I want to point out I'm not insinuating or implying in any way that those people were acting intentionally or lying. Meaning it's always easier to look in 2020 hindsight and be critical and pick things apart. That doesn't mean that the people who were doing it at the time or made the error were doing it intentionally or were lying. And I just want to be real clear about that, that I'm not accusing anyone of doing that, because as I was putting together this presentation and thinking about this, I could not think of a single incident where I actually believed that no matter how wrong the person was, they were doing it intentionally or they were intentionally lying. Just a little background. I've been involved in over 500 arrest-related death post-incidents on multiple continents. I've been retained as an expert hundreds of times. I have deposed or been present for medical examiners' depositions a lot. I've also deposed or been present for depositions of officers, experts, etc. And I've presented or co-presented, authored or co-authored with other people who do this a lot, to the tunes of thousands of incidents. So that's where I'm coming from with this, and these are some of the things I want to share with you today. When you look at the various consequences that can occur to an officer when that officer is involved in one of these incidents, always think about it from this perspective. Of course, at the highest, the officer can be criminally prosecuted, both at the federal level and the state level, and if it's on a Native American territory, also under their courts as well. And most officers don't understand or don't think about or realize that at the federal level, since about 1994, the maximum penalty for willful violation of a constitutional right that results in someone's death is the death penalty for the officer. So there are very extreme consequences that could befall an officer in dealing with these incidents. Civil liability, in other words, money damages or injunctions at the federal and state level, employment actions, termination, and discipline. And then at the bottom, of course, there's violation of so-called generally accepted, recommended, preferred practices or encouraged guidelines. We'll talk about more as we go through this. Here's what we're going to talk about today. I am going to ad nauseum drive home the less than once per career for all involved on average of these events. That is so important, because when you start looking at this from multiple people's perspectives and you realize that, hey, they're going to deal with this maybe once in their career, then you realize that there's no way they're going to deal with it perfectly in all respects. It just isn't going to happen. And that's why you've got to cut the people some slack, at least to a certain degree, but you also have to help them make as few mistakes as possible. So we're going to go into that. Learn from the mistakes of others. You will never do enough of these to do it on your own. So you've got to take the mistakes of others, learn from it, and then act in a better manner in the future. Beware the domino effect, which I'll explain. I'm going to give you two discussion scenarios. One of them is a civil amalgamation of cases of actual incident. And the second one is a criminal case where an officer was criminally prosecuted for voluntary manslaughter, and he went to trial in March. And perhaps I'll tell you what the outcome was. We're going to talk about importance of definitions, objective annotated chronological timeline, facts, qualified immunity, standards, degrees of certainty, and junk science. Less than once per career for all involved. Remember that. Just to give you an idea, use of force, depending upon how it's defined, is very rare. In other words, it's approximately one use of force, which is use of force above unresisted handcuffing in most people's definition, not always. In other words, there are definitions out there that say if you either threatened or actually touched someone, that's a use of force. So you have to be cautious on which definition you use. But I did include in the materials, the PDFs that I gave you, I think it's the second one, a number of studies covering 16.8 million encounters from the Canada, the US, that basically all come up with a consistent number. It's approximately 1 out of 1,000 to 1 out of 1,100 public encounters or calls for service that has a use of force. Then use of force with a CEW is more rare. It's about 1 out of 3,300. And then temporal to death. And here are the two that we're going to concentrate on. And that is for a law enforcement temporal arrest-related death. In other words, law enforcement officers were present, they acted, they touched him, whatever, and the person died. It's approximately 1 death for every 1 million public encounters or calls for service. And that's very consistent. For taser devices, it's 1 out of 3 million. But the one I'm going to use as an example today, in part because of the paper that Dr. Darrell Ross and I have just published, is on a naked arrest-related temporal death, which is approximately 1 in 10 million law enforcement public encounters or calls for service. Again, for the officer who has to deal with this individual, They don't care how rare it is because they're the ones who are going to face the consequences. To put this into perspective, since I'm using that criminal example of a firearm, in Bozeman's latest study on different frequencies of force, it's interesting that for every firearm death, there's 1,041,737 calls for service. And that's for a death. For every death, there were 6 non-deaths, though that's one out of approximately 187,000 encounters. But my whole point is all of this is the same. These are incredibly rare, and it's a good thing they are. And there's a huge difference between what people see on TV and what actually occurs. I've asked several people recently, and actually we're discussing doing a study on this, because of television, because of movies, because of the media, the sensationalistic media, what does the average person think for X number of officer encounters, there's a use of force, and for every X number of officer encounters, there's an officer shooting? The people I've talked to so far, again, this is not a scientific study, these are just the people I've talked to, but because of TV, shows like Cordell Walker, Texas Ranger, there's a lot of people out there that actually believe that for every 5 encounters, there's a use of force. And for every 20 encounters, there's a shooting. Well, those people will also comprise your jury. So those are one of the things that you've got to head off in advance, is to get people understanding the right numbers. Once in a lifetime, there are so many concepts out there that are like climbing Mount Everest. In other words, people might think, well, this is a simple concept. Yeah, no, it's not. When you look at so many concepts or so many issues when it comes to anything regarding these once in a lifetime events for law enforcement, or these temporal arrest related deaths or non-firearm temporal arrest related deaths, there are so many very deep learning curves. It is utterly amazing. Simple question. Go and look up, and yes, they do exist, according to the published peer-reviewed literature, how many additional firearm discharges will an officer discharging a firearm have from the moment the officer gets the signal to stop shooting? That's just one simple one. And you could spend probably, if you knew what you're doing, you could spend about a day looking it up to see exactly what the literature says about that. And there are any number of issues that go along with that, such as tell me, what are the papers that have been done on big epidemiological field studies with regard to people in prone positions, and then how many of them died from prone versus non-prone? Well, there have been several studies now done with that, and it's meaning several million people encounters, and we know those numbers. But my point is, if you've never researched it, if nobody's ever given it to you, if nobody synopsizes it for you, I doubt very many of us know what those answers are off the top of our head, or more importantly, where to actually find it. There's your library, start digging. And of course, if you had to look this way, it would take you forever, because the first thing you'll find are many of these papers are not in the library. In other words, you can purchase them online for $30 to $60 a piece, but actually finding them in a library is quite difficult. I decided to go back and take a graduate course online because I was interested, and they have a very, very large online library I have access to through them. And it's kind of interesting that I'm only finding about 1 out of 4 papers that I'm looking for in their library, which actually I find quite disappointing. But you have to pay attention to that, because just because you can't find something doesn't mean it doesn't exist. So what we're going to look at is, and keep in mind, is what causes a lot of the problems with these are misleading information sources by investigators, medical experts, and medical examiners, giving information to decision makers who then make decisions based upon that misleading information that have horrible or potentially horrible consequences. Just to give you one example, under medical, let's say we have a non-firearm temporal arrest related death, and a taser is used, and the person does die, and the person is brought by the emergency response personnel into the emergency room, and the doctor just off the cuff says, yeah, taser death. There you go. Then the person documenting what's going on documents that in the emergency room report. Then that will haunt you in the litigation for the next several years. You will not actually find it's wrong. You will not actually find that the doctor has no clue what he or she is talking about. You'll not actually find that it was just off the cuff statement with no support and it's not scientifically, methodologically reliable until about 2 or 3 years later when you finally depose that doctor, and the doctor will normally, at least in my experience, be quite incensed that you would dare question their knowledge and ability. However, I've had several times where that has occurred, and that is one of the reasons that spurred on either a criminal prosecution or a plaintiff's lawsuit, or caused a case to go forward because the judge felt, well, if the emergency room doctor thought the taser caused the death, I've got to let this go to a trial and let the trier of fact determine whether it did or not. The whole point. Over on the left, a lot of problems created because of incorrect statements or lack of evidence or lack of collection of evidence. Over on the right are people who make decisions based upon that information. We're not going to go through this slide. I gave this to you in your PDFs. Here's what's important about this. Over on the left, law enforcement officers. As we all know, for an officer to stop someone or seize them or briefly detain them on the street, the officer must have objectively reasonable suspicion the person is, has, or about to commit a crime. Okay, and then to frisk the person, the officer then has to have separate and distinct reasonable articulable suspicion that the person is armed and or dangerous. Then to arrest the person, the officer has to have probable cause, a fair probability of crime has been committed by this person. And for civil lawsuit purposes, the officer must have at least arguable probable cause in order to have acted appropriately under the correct legal threshold. My whole point is, over on the left, law enforcement officer, hey, you have to have objective reasons for doing what you're doing or you could be in big trouble, including jail, lawsuits, punitive damages, etc. In the middle, experts in federal cases are primarily controlled by Federal Rules of Evidence 702 and Federal Rules of Civil Procedure Rule 26. And what they basically say is, if you're going to give an opinion in federal court and have that opinion have weight and have the judge allow it, then it has to be scientifically, methodologically reliable, and the judge is the gatekeeper as to letting that in. In other words, you have to know what you're talking about and you have to be able to demonstrate it to the court for the judge to let you do this. Now go over to the right, medical examiners, forensic pathologists. You don't have to have any of that. I wish I could tell you I was wrong, but like I said, I've looked at over 500 of these. And from a total case perspective, meaning the investigation, the medical examiner, the forensic pathologist, all of this, the best grade I would give anyone I've ever seen, and not just in the US, this also holds true for the other countries I've been in as well, where I've seen these, is a C. And there are many reasons for this, but if the medical examiner had to comply or obey with even the officer's level of objective basis, or Rule 702 and Federal Civil Procedure 26, in my humble perspective, the world for law enforcement would be a much better place, because then they would actually have to have a basis for what they're saying. I can't even begin to guess how many temporal arrest-related deaths I've seen where a medical examiner, forensic pathologist, or coroner said, yes, it was either caused or contributed to by the conductor electrical weapon. They don't say by what mechanism. They don't say by what science. They don't say how they managed to rule that in. None of that. You don't get that until a couple of years later when you finally depose this person and say, why did you include this? I've actually had a couple say, well, we decided in our office to count them. So therefore, in other words, if a taser's involved, we're going to count it in our annual numbers. So therefore, that's why I put it in. That was about 2 years into a litigation that ended up costing about $2.5 million. So the whole point here is, on the left, officers have to have reasons for doing what they do or they get in huge trouble. In the middle, experts have to be methodologically reliable, be scientifically based, and have the experience, knowledge, and education to give their opinions. On the right, with medical examiners, none of that is true. The second thing is, medical examiners in most states, when they give their opinions, there is no mechanism to challenge it. Got that? There was an incident in 2004 and 5 where three different medical examiners out of the same office basically had law enforcement non-firearm temporal arrest-related deaths, and they basically said all three were homicides, and they gave a number of reasons, including taser devices, prone restraints, etc. And in one of those three cases, 5 deputy sheriffs were criminally prosecuted. In the state where this occurred, that was one of the few states where they could be challenged. We did challenge them. I mean Taser International. And it had a full trial on it. And at the end of the trial, the judge ordered the 3 medical examiners to change their reports. They appealed that to the Court of Appeals. They lost. They appealed that to the state Supreme Court. They lost. So there are a handful of states where you can challenge their opinions, but they're very few and rare. The second thing is, since the medical examiner forensic pathologist is doing this for the government, they are basically allowed to say things, well, my opinion is X, whatever that is, and then the law automatically bumps it up, conflates it to being scientifically valid, even when it's not. So anyway, you've got this chart if you want it, but it's important to keep this in mind because so many people, police chiefs, prosecutors, et cetera, make decisions based off of medical examiner reports where they shouldn't. And hopefully the investigator and the use of force expert can help head some of this off. Okay, some fact issues. Failure to use comprehensive, easy to use investigative checklists. First, none exist. And here's what I mean by that. What I mean is, okay, bear in mind, approximately 85% of all the police agencies in the United States have 10 officers or less. Your officers have a non-firearm temporal arrest-related death tonight at 2 a.m. Chief calls you and say, okay, investigator Johnson, investigate this. There you go. You've never had one before. You're likely never have another one in your entire career. Where do you start and what do you do? Where you should start is a complete, comprehensive, easy to pick up and within 30 seconds use checklists to where you do not miss anything, capturing, collecting, maintaining, and setting it up as reliable evidence. The problem is, at present, at least to my knowledge, those don't exist. Now, myself and I've got a few people working with me on this are working on a draft set of these, but they're only in draft mode, but that's why I left this in here. If anybody wants to see them, edit, comment on them, whatever, or have a set of them, I don't care. I'll be more than happy to give them to you. And if you've got comments or edits, etc., I'm more than happy. I would love to have those because the whole idea is to make these as helpful as possible for that officer who gets that assignment at 3 a.m., who goes, what do I do? In other words, right now, if that officer gets that, sure, there are places they can go. There are books they can get. There are treatises they can look up. There are several hundred scientific papers they can purchase. That doesn't help them at 3 a.m. Sending you 1,000 pages to read, digest, and then try to apply isn't going to cut it. Now, if you do want to do this in advance, there are places you can go. For my thoughts, the best book on this that presently exists is Dr. Darrell Ross and all of his co-authors, Guidelines for Investigating Officer-Involved Shootings, Arrest-Related Deaths, and Deaths in Custody. And it has numerous checklists in the book. However, and Darrell and I have Dr. Ross and I have discussed this, the point is you can't just at 3 a.m. in the morning pick this up and use the checklist because you're not going to understand the checklist if you haven't read the chapter. So therefore, it doesn't accomplish what I'm trying to accomplish by those previous drafts. A second book is this one. The current version came out in January of this year. It's the 4th version, Clinical Forensic Medicine. There are chapters on restraints. There are chapters on excited delirium. There are chapters on arrest-related and in-custody deaths. There are chapters on conducted energy weapons. There are chapters on handcuffing. And it's out of the United Kingdom is where the author comes from. Several of the officers come out of the U.S. And it is a very good book. And again, like all these books, every one of them has mistakes. But when they get 90 to 95% or better correct, it's a pretty darn good resource, and it's a heck of a good place to start. If you want it, I have a selected science outline that I've been keeping up now for approximately, 10, 15 years. It's right now, I think, about 550 pages. It is a reference resource, meaning if you want to know what pigs have had cardiac capture caused by a conducted electrical weapon drive stun in any study. It's fully hyperlinked to the table of contents, table of tables, and tables of figures. You can go there and find that. If you want to know what are all of the papers out there that talk about undetermined cause of death as it pertains to law enforcement arrest-related death, they're all in there. If you want to know the very first time the terms excited delirium appeared in the medical, scientific, or religious literature, there's a table in there with the full citation. It's in there. Therefore, this is not going to educate you. This is not going to teach you a whole lot. What it's going to do is, if you've got a question, it's going to say, hey, here's where to start, here's where to go, here's what to look at, here's the research that exists. And I always put it at that web address, so the latest one, no matter what date it is, will always be titled the number 1.pdf at that web address. There is no website there, so you have to have that web address to find it. Okay. Now, some of the other things that occurred are the failure to create an easy-to-use, objective, annotated chronological checklist. This is incredibly important. It's virtually never done. Because in today's world, especially with what we have available, dispatch logs of body-worn cameras, squad cameras, all of this, we have the capability to do this. Nobody does it. Rephrase, I've never seen one yet, but it would sure help the officers if they would. Then you have fill-in versus gotcha investigations. I can't tell you how many times I've seen an investigator say, well, how many times you hit him? And whoever did the hitting says X, say 4. And then they look at the body-worn camera and it shows 6. Well, if you understand human factors and what goes into these force events and what happens to stress and your thought process and your ability to think and remember, there's no officer that I know who's Commander Data, or even Mr. Spock for that matter. They're not going to remember these things. Now, sometimes they might, but you sure can't rely on them. But when you ask these kind of questions, you're going to get a whole bunch of fill-ins that are going to create what someone else will construe as fact issues. Now, they may or may not be relevant, but it doesn't matter. If the judge deems them a fact issue, that's what can happen. Now, so what I mean by this, example, let's say you use a taser on the guy, and I'm going to give you an example in a minute, and you pull the trigger 4 times. And you're using a new smart taser, so therefore you've got pulse logs. And the pulse logs will tell you whether or not charge was actually delivered to the individual. Okay, so now you know this, you've got the complete timeline, you've got it in front of you, you know how many pulses were delivered, and rather than ask the officer, okay, how many times you pull the trigger, you say, okay, here's when you pull the trigger the first time, here is when you actually connected to the person, what behaviors were you seeing before you did that? What behaviors were you saying once you did that? And then what behaviors did you see after you did it? It's the difference between fill in the chronological timeline events versus gotcha. Unknowingly throwing hand grenades, such as, well, they didn't use the recovery position. Yeah, I hate to tell you, but the recovery position is a misnomer. People don't recover in the recovery position. That's part of the problem. It was a term that was designed for EMS, first responders, and officers in order to give them a way to explain this, which is basically laying on their left side, so if they vomit, they won't vomit into their lungs. But they termed it recovery position. The problem is people actually think the term recovery means that they're going to recover. No, they don't. So you have to look out for throwing those kind of grenades that don't have those meanings. Failure to identify, capture, properly maintain, analyze evidentiary. Inappropriate reliance on so-called experts, often in-house. I'll give you an example of that in a minute. Medical examiners, forensic pathologists, we already talked about. Beware conflating a definition of policy, procedure, etc., to a standard with consequences, such as federal civil rights law or state procedural law or state criminal law, etc. Training, policy and training dictates that are not properly based on science and the law. As an example, I'm still seeing policies to this day that say, as an example, you shall not ever, under any circumstances, use a taser for more than 15 seconds, either individual or cumulative. Okay? I know where that comes from. I know where I first heard it in 2005 in Boston at the IACP conference, and I know who said it, and I know how it got out of control. The problem is, scientifically, what is the difference between 14 seconds or 16 seconds of taser use? The answer is there is none. So when you start looking at these policy or training prohibitions, mandates, et cetera, you have to decide whether or not they're based on science and or the law. A lot of times they're not. Failing to follow the methodologically reliable greater weight of the science. Bear in mind, there's quite a bit of legal precedent out there that's 10 years out of date. And this especially applies to prone restraint as well as hog tying, et cetera. So because of that, things that might have been in the science 10, 12 years ago that have now basically been debunked, you can still be held accountable for today because the law has not kept up with the science. Also, when you're providing policy, training, et cetera, bear in mind, one of the aspects to think about is who is your final arbiter who might look at this? That's the judge and the jury. In other words, if while you're going through training on whatever you're going through it on, if there's some short video that clearly explains the concept you're trying to get across, put that in your training, document that it's in there, be sure your officers see it and they're tested on it. So therefore, if it becomes an issue later on, you've got a much higher probability of being able to show that to the judge and jury. I have no idea where that red line came from. I apologize. So keep in mind, less than once per career for everybody, not just the officers, everybody. Example, forensic pathologists. I know a certain forensic pathologist pretty well from a major city, and I've known him since 2004. And I've asked him, I said, okay, in your major city, your major county, how many excited delirium type arrest-related deaths do you have annually? And he said 6. Okay. And how many forensic pathologists do you have in your office? 9. And that is in an extremely busy city. So it's very rare. Also, keep in mind, if you're the officer who just took some kind of an action, who do you trust to be highly knowledgeable, unbiased, fair, and just? Media? Special interest groups? Anybody within your department? No, I'm not asking you to actually say it. The government entity, investigators, medical examiners, local prosecutors, state prosecutors, federal prosecutors. How about the Civil Rights Division of the U.S. Department of Justice? Do you believe that they're pro-law enforcement? If you do, we need to have a serious discussion. Others. All others, you know what can happen to you. Criminal prosecutions, civil lawsuits, lose your job, your career, et cetera. But if in the process of reviewing what you did and making decisions on it, what are the negative things that can happen to an incompetent investigator, a wrong forensic pathologist, an agency executive who gets it wrong, the trainers who make a mistake, government officials who go after you by making a mistake, prosecutors who prosecute you when they shouldn't, judges? I think you can answer that for yourself. If you need me to answer it for it, I will tell you in almost every instance, the word is nothing. Okay, discussion scenario 1. Multiple 911 calls at 10 p.m. of a naked male, about 20, running, jumping on cars, passing cars, striking cars, etc. Officers in EMS, including fire, are dispatched. The reason why fire is dispatched because they always roll for manpower to back up EMS. That's a jurisdictional thing. Some places they do, some places they don't. All officers and cars have body-worn cameras. EMS and fire arrive first. They stage a block away because they're not going to deal with this guy until officers arrive, capture, control, restrain him, and deliver him to medical care. First officer arrives, does not engage, tries de-escalation. Why? Because for the last few years, that's the current hot button. Most experts that I'm aware of will tell you that under this scenario of the naked male bouncing off of cars, striking cars, jumping on cars, de-escalation is not going to be very fruitful. Second officer arrives, attempts strategic positioning. Then the subject attempts to jump in the first officer's running car, you know, the one where there's guns in the front seat. And the second, so then they try to restrain him. The second officer uses an X2 smart CEW to the mid-back from close distance, 5-inch probe spread, 4 trigger pulls over 28 seconds with 22 seconds of discharge. If you understand those, if you understand all that, that has all extremely particular meaning. 2 additional officers arrive. Officers wrestle the person to the ground, put him in handcuffs. While struggling, he resists, fights, restrains, grunting. They put him in on his stomach, prone position. EMS fire are called. Before they get there, he kicks. One of the other officers gets too close, and the flailing gentleman kicks him in his bad knee. The kicked officer draws his X26E, not a smart CEW, removes the cartridge, and either drive, contact, or touch stuns the individual. By the way, all three of those are different, with a 5-second total discharge time. EMS fire arrive at subject. Subject goes unresponsive, weak carotid pulse, breathing, automated external defibrillator applied, says no shock. They perform CPR, goes to the hospital, pronounced dead. Investigator Smith assigned to investigate this. It's his first one ever. Medical examiner, forensic pathologist documents cause of death. Cardiac arrest following 5 50,000 volt electric shock applications from a conducted electrical weapon and prone restraint. Contributing factors: methamphetamine, THC, ethanol. Excited delirium syndrome ruled out because the medical examiner's never seen it, never researched it, does not believe in it. Manner of death: homicide. Okay, what are the very likely repercussions from this for those officers, especially the one that used the taser X26E on him when he got kicked in the knee? There's a pretty strong probability of, number one, community outrage. Number two, criminal prosecution. Number three, I can pretty much guarantee you there will be a big civil lawsuit with potential losses in the millions. And there will also be potential discipline and termination of the officers, especially if they violated department policy, especially if that policy is considerably more restrictive than federal law. Okay, discussion scenario 2. I wish I could tell you this one I made up. I didn't. This is the officer who went to trial on voluntary manslaughter charges in March. Government's in-house expert in state criminal prosecution, a police officer for voluntary manslaughter. The prosecutor in part made his decision to prosecute this officer based upon the in-house expert's opinions. In his 78-page report to the district attorney on law enforcement agency letterhead, on police academy letterhead, includes an internationally accredited law enforcement agency. The expert says, legal advice and practice of law, the expert services rendered in this case and this document do not constitute legal advice. Okay. A couple paragraphs down, here are his conclusions. 1, officer did not possess the requisite probable cause to believe the subject represented an imminent threat of death, of serious bodily injury or death. I don't know about you, but that sounds an awful lot like a legal conclusion. Secondly, let's say that we were deposing that expert and said, okay, define probable cause for me. Should be interesting. Next, tell me the difference between an imminent threat and immediate threat. According to Garner, Graham, and the other key U.S. Supreme Court cases that deal with deadly force, do they use the term imminent threat or immediate threat, and what's the difference? Tell me what is the difference between serious bodily injury under federal law, state law, and under the particular statutes that this officer is being prosecuted under. Should make for an interesting deposition. Number 2, officer's use of deadly force was unnecessary and contrary to the parameters set forth by state's criminal justification statute. Again, sounds an awful lot to me like a legal opinion. But I don't think the officer would likely hold up well under a deposition. 3, the deadly force utilized by the officer was objectively unreasonable considering the facts and circumstances known to him at the time of the application of force. Okay, how about I simply ask the officer, officer, tell me, what was the clearly established law pertinent to this jurisdiction under which you're finding this officer acted objectively unreasonable? Go. I don't think he would be enjoying his day. But again, next, the deadly force utilized by the officer upon subject did not conform with applicable standards set forth by the agency's use of force weapons policy. Okay. So what? So now we're going to take the agency's policy and elevate it up to a potential criminal violation and criminally prosecute the officer for voluntary manslaughter because the officer violated the department's policy? Which, by the way, in this particular policy, there were multiple standards on a single page. And the next one, officer demonstrated deficiencies in relation to recognized principles that are fundamental to sound tactical performance. I'm not the one who misspelled principles. Question for you. There's over 1 million officers in the country. So who decides what a demonstrated deficiency is in fundamental sound tactical performance, which is sufficient enough to prosecute the officer for voluntary manslaughter at the state level, put him through a 2-week jury trial, and try to get him to be put away in prison? Now, if you're following along here, my whole point is, what exactly were the standards? What exactly were the culpability thresholds? What exactly were the definitions? And what exactly needs to be violated in order to properly have consequences on the officer? That's the whole point here. And actually, it was this case that caused me to put together this presentation. Now, if you really want to know, thank God the officer was found not guilty. I'm showing you this. This is my dominoes. What I mean here is when the investigator, the expert, or the medical examiner say something or do something or state something that's wrong, they're the ones who can start the dominoes falling, which means the decision makers then can rely on what they did and start taking actions, often which can be negative. Definitions. Virtually nobody does this either, but they should use clearly defined definitions, have an accepted lexicon to refer to, preferably from reliable, authoritative sources with full citations. It gives them more gravitas. Avoid loaded words that give false implications or false equivalencies. As an example, if anybody out there reads law review journal articles that deal with law enforcement use of force, before August of 2014, you might remember that was the Ferguson incident, there was very little use of the term police violence. Since then, there have been many law review journal articles written on police violence. Now, most of the articles, not all, but most, if you read them, what they're really saying is police use of force, but they're using police violence to explain it. Okay. Well, how do most people interpret, most lay people will call them, oh, I don't know, jurors, the term police violence? So therefore, that's a loaded word that unless you actually mean that, you shouldn't be using it because of the false implication and false equivalency that it gives to other people. And then, of course, the word excessive. Avoid a word or phrase having multiple meanings or interpretations. Examples, CEW deployment. I had an attorney call me about a week ago and say, yeah, they deployed the taser device 18 times. Okay. So he changed cartridges out 18 times? Incapacitation. What does that mean? And whose definition are you using and where does it come from? I suggest you use the 2012 whole paper that defines incapacitation performance when it comes to a conducted electrical weapon, but you have to have a definition for it. Reasonable. What does reasonable mean? A lot of people think they know what it is, but what is it and how is it going to be applied to your investigation in your case? Objective annotated chronological timeline. Okay, hurry up, take this down. I'm kidding. All 3 of these pages are in your PDF document. The first two pages, this one and the next one, only show you the system I went through the process to develop the third one. This is the actual checklist. And basically what this means is collect all of the objective time-related information, properly accumulate it, sync it, transcribe it, don't screw it up, and that's what you're going to use to build your case upon. Because that is objective, documented, and you even have the variances. But that's the sheet to use, is the third one. Facts. Gather, collect, maintain, organize all objective facts, process those facts, properly analyze them, determine fact issues. As an example, A, how many fact issues has the investigator created when they shouldn't have? But B, how many fact issues are related to and clearly define, clearly established law? Meaning, if an officer says that he used a taser on somebody for 3 seconds while the person was actively resisting, and he actually used it 4, can that create a fact issue? Yeah, it can. But does it matter? And the answer is no. The fact differences and fact issues and conflicts that matter are the ones that are determinative on whether or not clearly established law was or was not violated. And then consider outputs and deliverables. Who are you providing your reports to and what format do they have to be in? Meaning, city council wants a one-pager and then wants you to answer questions. The attorneys you're working with, they want everything in a usable format. The experts you're working with want everything fully annotated, cited, and well organized so they can make better use of it. Okay, definitions, many, almost all, failures to use definitions. Timeline, use a timeline. Transcriptions, example, in the exorcism case out of Arizona, it was transcribed by a person who was not a very good transcriptionist. 3 years later, they realized that the transcriptionist left out 2 determinative words. In other words, left out the word not 2 different times, which totally changed the meaning of what the officer did. In other words, you got, in my humble opinion, you have to transcribe it, but you also have to verify and confirm the transcription is accurate. Fact conflicts, if you can do so completely fairly, transparently explain it, neutralize the fact issues. For gosh sakes, don't change someone's facts unless you completely, thoroughly document it so that anyone following this in the future will know exactly what you did, why you did it, how it was done, and for what reasons. Otherwise, you can easily find yourself being criminally prosecuted. Reporting triage. You're going to need to decide what level of reporting and investigation you're going to do on this, obviously. And right now, we've been talking mostly about law enforcement temporal death issues, but obviously, you're going to have to decide what level of investigation you're going to do. One of the things that I actually kind of like is if you look at the Civil Rights Division of the DOJ, you look at their consent decrees, they have 4 or 5 different levels of, if here's the level of force that was used, it dictates what level of triage it would use. It really isn't bad, and it gives you an authoritative source. CEWs, multiple issues. Media, by that I mean recordings. Too many times they fail to capture the media and maintain it in its native format. Because if you start messing with it and it's not in its native format, you're going to have losses. Then they don't sync it. Many do not look at the human factors involved. In other words, what exactly is a human capable of and how's it going to be recorded? Measurements. If any measurements you take have to be completely clear, accurate, to scale, and in context. Example, I saw an autopsy photo the other day with several pictures of wounds with no scale, no ruler, no reference point, no physiologic landmark, nothing. Translation, they were absolutely useless. Biosamples, I won't even begin to discuss how many cases I've seen. Well, I realized that the lawsuit didn't come for 2 years, but we disposed of all biosamples after 6 months because that's our policy. Good luck with that. Knowledgeable experts, most of the really top experts out there will talk to you. In other words, if you call them and say, look, here's what I think my problem is, they'll give you some guidance on where to go and send you a couple of key papers on what to start with to at least give you a starting point on what to look for. Don't hesitate to call them. Every one of them that I know is a nice person, and in the end, what they want is to do what's right, and they want everything to be fair, just, and transparent. A couple of quick examples. UK, failure to document, capture, maintain the subject's sweatpants. There was an incident. They used a taser, and the man ended up dying in his kitchen floor. The investigator came from several hours away. However, he was going on holiday the next morning. He turned it over to another investigator who couldn't get there for 2 days. The person who was supposed to videotape the incident, her camera was broke. The person who was supposed to take still photos was on holiday. And the issue was, the officer said, I used this force because he put his hand in his sweatpants pocket and I was told he had a knife. So the question is, did his sweatpants have a pocket? Well, nobody videotaped it. Nobody took a picture of it. They put him into evidence, and then somebody else later destroyed the sweatpants. There you go. You've just created an issue. And it was a key issue in that case. Now, the next one is in that same case. Because the kitchen, the house was locked up, so one of the officers felt sorry for the bulldog. So they put the bulldog in there overnight, even though the incident scene had not been processed yet, to basically be kind and compassionate to the bulldog, which I agree, be kind and compassionate to the bulldog. However, totally contaminating the scene by letting the dog in there and spend the night probably wasn't the best issue. UK extreme expert. In that same incident, the UK medical examiner hired the ultimate expert. I mean, this guy had credentials like you would not believe, but none of them were on the issues of this case. It did not stop him from writing his full report, basically blaming the officers for the death. It wasn't until certain questions were asked where luckily that expert had enough personal gravitas to say, this is over my head. I don't know the answers to these. You're going to have to find somebody else. Not everyone does that. Luckily, this man did. Force expert, who was less than optimal, issues of positioning. Same thing. Basically, in that 5-week inquest, 2 of the top instructors from the country were brought in to testify, and the plaintiffs, the 3 government attorneys hired by the government to represent the family, said, well, isn't it true that you're not supposed to prone them out or put them on their stomachs? Yes. And isn't it true because that kills them? And the expert said, yes, that's because that's what we've always been taught. We all know that, and therefore you shouldn't do it. Not scientifically valid, incorrect, but that was their policy, and handed the plaintiffs exactly what they wanted. A Georgia incident, they used 3 different cardiac defibrillators on this individual. They never once captured any of the downloads, any of the records, the presenting cardiac rhythm, none of it. Florida dispatch recording. It was a death incident. There were multiple dispatch recordings from multiple channels. The director of the dispatch center said, okay, capture all this. They did. The problem is they cut out all the blank time. Therefore, to create a chronological timeline was absolutely useless because the person who made the tape, the recording from the dispatch original records, cut out all the dead time, believing that they were doing them a favor. In reality, they destroyed incredibly important evidence. I already told you about this one, officer's statement, the difference between I did it versus I did not do it. You got to check the transcriptions. Okay, conflating false equivalencies. Beware of somebody's policy being amped up to clearly established law. Beware of policy creating current science to the greater weight of methodologically reliable. Watch out for an expert's ipsa dixit, in other words, their own opinion, establishing fact, science, or law. Experts' limited knowledge is their training. Exactly how deep is it? Beware of the so-called best preferred practice, industry standard, consistent with accepted police practices, all of this line. There are over 1 million officers in this country. There's over 18,000 police agencies. Other than obeying the federal law, what else do they do that is absolutely consistent across all police agencies? Logical fallacies, such as temporal equals causal. Other things that can cause death, and we know this, stress, undeterminable. And then, of course, we already talked about Federal Rules of Evidence 702 and Federal Rules of Civil Procedure 26. Okay, I show you this slide because too many people jump into, okay, this is under Graham, we got to decide as objectively reasonable. Now, the first thing you have to decide is the qualified immunity question. Did the officer violate clearly established law? And was that clearly established law known and understandable and beyond debate to all officers at the time of its use? So take any use of force event that you've ever thought about and ask yourself those questions. And in a great number of them, you're going to find out, okay, no, the officer didn't violate clearly established law. Now, then you can start debating and arguing and everything else as to whether or not the officer's use of force was correct or not under the correctly applied legal standard. But just think about this for a minute. Under qualified immunity, if 2 knowledgeable trainers can debate it, that automatically means what? That automatically means, under the U.S. Supreme Court's dictates, the officer's entitled to qualified immunity, by definition. Okay, then at the bottom, number 3, make sure you're using the correct standard, correct level of culpability, and correct degree of certainty. Qualified immunity, real quick. The 4th Amendment addresses misuse of power, not the accidental effects of otherwise lawful conduct. It protects all but the plainly incompetent or those who knowingly violate the law. and was it beyond debate? The specific question to be asked. Skip that. Skip. Okay. All right. Culpability standards. When you start looking at definitions, which one are you using? The one to be most concerned about, of course, is willfully. By the way, I gave you in your handout a 7-page glossary of these, so you've got them all. But the two key ones are willfully and knowingly. In law, the use of the words willfully generally implies a purpose to do wrong. Doing a thing knowingly and willfully implies not only a knowledge of the thing done, but a determinative to do it with evil purpose or motive. Is that your definition? Well, that's the correctly applied definition. Considering standards. There are different standards based upon the consequences. The shall standards, such as for employment, such as discipline, termination, career ending, civil litigation, criminal prosecutions, and then should best practices. So therefore, look at your policy and figure out how many different standards are in there. And for every time a statement is made or there's something that will cause an officer to be sanctioned or there be consequences for that officer, whatever they are, discipline, terminations, criminal prosecution, whatever, ask yourself, what is it based on? Is it based on the law? Is it appropriately based on the law? Is it correct with the appropriate science? And is the correct adjective in place as to such as shall, may, etc.? Do not mix up the law requires X, legal consequences. Your department requires Y, administrative consequences. You're encouraged to do Z, no consequences. Simple example. Officers need to obey the law in their use of force. But what do we want them to do? We actually want them to use the bare minimum force necessary to accomplish lawful objectives. Those are two very different things. Don't confuse them. Skip that. Okay. I gave you this little chart so you can see it. It basically says, look, there are different standards that apply, such as if the person is convicted and incarcerated, the standard is do not use cruel and unusual punishment. If it's under the Fourth Amendment, then it's objective reasonableness. If it's under Fourth Amendment detainee in detention center, up until 2015, it was a due process violation. Now it is objective reasonableness under Kingsley. By the way, Dr. John Peters was an expert for the defense in that case, if you're interested. But just bear in mind, there are different standards. There's a lot of people out there that say that, oh, every one of these falls under objective reasonableness. No, they don't. That's like saying that all uses of force only apply to citizens. No, they don't. It applies to any human being on government soil, whether they're a citizen or not. Degrees of certainty, I gave you this chart as well. It should be self-explanatory to most of you, but the key ones are the ones that officers rely upon, which are above the Fourth Amendment line and preponderance of the evidence. The reason I made this up in the first place was because I was reading an officer's deposition, and the plaintiff's attorney said, well, how sure were you of X? And the officer said, I was 99% sure. And plaintiff's attorney attacked them at length. Well, you weren't 100% sure, were you? All the officer had to be was about 50%. But the officer didn't understand that. So the officer got really shook. So it's important to understand these different levels of certainty. Junk science. Okay, bottom line, watch out for all the negatives. Case reports, case series, old science is not methodologically reliable, and it has to be to the correct degree of certainty, and you've got to watch out for societal pressures on the medical examiner. And if you want to go through this, there's also, we could do a whole course on this too, but basically it's for a medical examiner to get it right. And here's your checklist, and I only have 18 seconds to go. That's why I'm now rushing. But basically, what I look for when I see an autopsy report and when a medical examiner blames something, prone restraint, pepper spray, taser, whatever, the first thing I look at is by what mechanism? What mechanism did it allegedly kill them? And my time is up. Thank you very much. I hope I didn't rush too fast, and I hope you got some value out of this. Have a wonderful day.
Well, hello, everybody. This is John Peters. We're going to do our Kahoot learning check in just a moment. I apologize for not being on earlier, but I had a lot of technical problems from a Microsoft update early this morning. So hopefully those have all been resolved. If you have Kahoot, get it ready. You should have it downloaded, and we're going to start. This is the number that you put into Kahoot, 892-195. And the winner of the learning check will get a free virtual seat in the corrections legal program put on by AELE in January. So go ahead, and we'll give you a couple moments here to join Kahoot. And then after we get, I think we're up to 5 players so far, we'll probably have a couple more join us. And we wish you all the best of luck as we get started on this. We had, by the way, over 200 people this morning, I believe, on the webinar broadcast, and we really appreciate that. The links to the handouts are on the AELE website, and it's under webinars, so feel free to go to webinars and you will find those PDF handouts. If you have not been to the AELE website in a bit, check it out. We totally redid it, and it is brand new and easy to navigate. So we hope you enjoy all the hard work for that. We have one more webinar coming up next month that is part of the no-cost AELE webinar series. Dr. Darrell Ross is going to be presenting next month on his research about law enforcement properly handling naked subjects, positional restraint, and the research that he did and published. You would not want to miss that. We'll be sending out a notice on that very, very soon. I believe we're up to 23 players for Kahoot. So again, remember, as you see the questions and the answers come up, answer those on your phone. Push the appropriate or touch the appropriate block for your answer. And again, we appreciate all of you who joined us this morning, and hopefully we won't have any more technical issues as we move forward. We're up to 27 players. This is going to be quite a competition. We haven't had this many players in the past. We had, I believe, up to 20, but we're now up to 30. So it's going to be competitive. And again, the winner gets a virtual seat at the AELE Jail Legal Issues Seminar scheduled for January of 2021. Just before we start, I might mention that we have the Discipline and Internal Affairs and Investigations Seminar scheduled in September in Las Vegas. Las Vegas is opening. We anticipate the city to be fully open in September, and you can come and visit us live. We will take care of all the social distancing and sanitation issues, or for the first time, you may attend virtually as well. Well, I don't see any more players, so we will get started with Kahoot.
How many questions you got?
Well, it looks like MSP 2678 is our winner. Congratulations. MSP 2678, send me an email and or in your chat box, just give us your name so I know who to put on to that certificate. Again, folks, thanks for attending the AELE webinar today. Our thanks to Attorney Mike Brave. The comments that are coming in from chat are very, very positive. We appreciate it. This webinar will be uploaded yet this week and will be available for viewing online. Again, thank you for your time, and be looking forward to seeing everybody next month with Dr. Darrell Ross. Thank you.